thief of the Canadian energy sector. The woman who stole 12 years of her former partner's work and built a company worth $300 million on the back of it. That was what they called Sylvia Okafor-Brennan before the trial even began. Except her name wasn't Sylvia Okafor-Brennan. Her name was Claudette Osei, 44 years old, founder and CEO of Lumara Energy Solutions, and she had never stolen anything in her life. But the press didn't know that yet, and on the morning of October 14th, when she walked through the glass doors of the Ontario Superior Court of Justice in Toronto, the cameras were already waiting. She walked in alone. That should have been the first sign that something was wrong. 3 years earlier, Claudette had done what most people in her position never do. She had walked away from a six-figure consulting contract at a major utility firm, cashed out her modest retirement savings, and started Lumara from a rented desk in a co-working space in Mississauga. The idea was simple in the way that most brilliant ideas are simple: a proprietary forecasting model that could predict regional energy demand fluctuations with an accuracy no existing system had managed. It saved municipalities money. It reduced waste. It worked. What Claudette hadn't anticipated was that it would work so well that a man named Victor Ashburn would notice. Victor Ashburn was 61 years old and had spent 3 decades accumulating influence in Ontario's energy sector, the way some men accumulate debt. Quietly, consistently, and without much thought for who eventually had to pay. He was the executive chairman of Courland Power Group, a privately held firm with contracts across 4 provinces, and he did not like being outperformed by a woman who had started her company with less capital than he spent on client dinners in Ingle Quarter. The lawsuits began in the spring. First came the intellectual property claim. Courland alleged that Claudette's forecasting model had been derived from proprietary research developed during a brief consulting arrangement she'd had with one of their subsidiary firms 8 years prior. The claim was, anyone who examined the timeline carefully, impossible. The subsidiary in question had dissolved 4 years before Lumara existed. The research Courland cited had never been published, never been filed, and, according to their own internal records, had been abandoned. Courland had lawyers, expensive ones, and Claudette, despite the quiet success of Lumara, did not have the kind of money that buys a legal team capable of fighting a 3-year war of attrition. She hired the firm of Decker, Morse & Callahan. They were not cheap, but they were not the best either. She paid their retainer in installments. The morning the trial was supposed to begin, Claudette arrived at the courthouse at 7:45. Her lead counsel, a polished woman named Andrea Ferris, had assured her the previous evening that everything was prepared. The documents were organized. The witnesses were confirmed. The strategy was set. At 8:17, Andrea Ferris called. The firm was withdrawing from the case. Claudette stood in the marble corridor outside courtroom 4 and listened to the words without fully understanding them. "Withdraw, conflict of interest," Andrea said, her voice carrying the particular smoothness of someone who has rehearsed a difficult conversation until it no longer feels difficult. She was sorry. She truly was. The firm had become aware of a situation. She couldn't say more, but they had filed the appropriate notice with the court. The call lasted 4 minutes. Claudette put her phone in her coat pocket and stood very still for a moment. Around her, the courthouse moved. Clerks with folders, lawyers in groups of 2 and 3, speaking in low voices. A security guard near the door eating a granola bar with quiet concentration. She went into the courtroom and sat down at the defendant's table and waited. The judge was the Honorable Patricia Kwan, 57 years old, known for efficiency and an almost complete intolerance for procedural games. She had presided over commercial litigation for 11 years. She had seen lawyers withdraw before. She had seen clients left stranded. She did not enjoy it, but she understood it as a feature of a system that sometimes ground people down by design. When she entered the courtroom at 9 and reviewed the withdrawal notice on her desk, she looked up at Claudette with an expression that was not unkind but was not particularly hopeful either. "Mrs. Osei," she said, "it appears you're without representation this morning." "Yes, Your Honor. Do you require time to retain new counsel?" Claudette had spent the 40 minutes since Andrea's call doing calculations in her head. She knew what new counsel would cost at this stage. She knew what delays would cost Lumara. She knew that Corlin's lawyers would use every extension to file additional motions, run up costs, exhaust her further. She had been in this fight for 3 years. She was already exhausted. "I'm not sure time would help me," she said quietly. Judge Kwan looked at her for a long moment. Then she looked at the Corland legal team, 4 of them arranged in a neat, expensive row across the aisle. Their lead counsel, a silver-haired man named Dennis Haverford, had the careful blankness of someone trying very hard not to look pleased. "We'll take a brief recess," Judge Kwan said. The maintenance staff at the Ontario Superior Court worked early. They were finished with most of the public areas by 8:30, which meant that by the time proceedings began, the hallways were clean and the courtrooms had been swept, and the large utility closet near the east stairwell had been locked up, and the man who locked it was usually done for the morning. Except that Tuesday morning there was a broken seal on one of the windows in the corridor near courtroom 4, and the custodial supervisor had asked if someone could handle it before it became a draft issue for the afternoon session. That someone was Malcolm Tate. Malcolm was 38 years old and had worked building services for the court for 6 years. Before that, he'd done general maintenance at a hospital in Hamilton, and before that he'd spent 2 years taking night classes at Mohawk College toward a paralegal certificate he'd never finished. Life had intervened in the way life sometimes does, specifically in the form of his daughter Rosie, who was 7 now, and who had been 3 when her mother left and had not seen her since. Malcolm had not finished his paralegal certificate, but he had read the textbooks. All of them. Twice. He read the way some people watch television. Not for any particular goal, just because it quieted something in his head that didn't quiet easily. He was applying weather stripping to the corridor window at 9:05 when the doors to courtroom 4 opened, and a woman walked out alone and sat down on the bench across the hall and put her face in her hands. He kept working. It wasn't his business. But then he heard her say, very quietly to no one, 3 years. He didn't turn around. He finished the strip on the left side of the frame. Then, because he was someone who had learned that pretending not to notice things rarely helped anyone, he said, "You okay?" She looked up. She was composed, or nearly. "Fine," she said, in the way people say fine when they mean the opposite. "Court stuff?" She looked at him for a moment, at his gray work uniform, his toolbox, the roll of weather stripping in his hand, and then something in her expression shifted. Not relief, more like the recognition that there was no longer any point in maintaining a particular kind of front. "My lawyers just quit," she said 40 minutes ago, on the phone. "The trial started this morning." Malcolm set down the weather stripping. "Who's the other side?" "Corland Power Group." He was quiet for a moment. Then he said, "Victor Ashburn." She looked at him differently now. "You know him?" "I know the name." He'd read the filings in 3 different commercial cases that had come through this building over the past 2 years. Corland appeared in 2 of them. Ashburn's name was in the footnotes. He'd read the footnotes. "Your forecasting model. That's what they're claiming." "How do you?" "I work here," he said simply. "You read things." There was a silence. In the courtroom behind the closed doors, someone's phone went off and was quickly silenced. "What's your name?" Claudette asked. "Malcolm Tate. Claudette Osei." She paused. "I don't suppose you finished your law degree paralegal certificate." "Didn't finish." "Right." She almost smiled. It was not a happy smile, but it was a real one. "Well," Malcolm picked up his toolbox. He put it down again. He thought about Rosie, who had drawn him a picture that morning of a lion and a small person standing beside the lion, and had written at the bottom in her large uneven letters, in the way she always did when she wanted him to take it with him. "For when you need it." He had folded it and put it in his shirt pocket. He could feel it now. "I'm not a lawyer," he said. "No. And I'm not saying I can." He stopped. Started again. "What documents do they have?" "The ones they're claiming prove derivation." She blinked. "A licensing agreement. Dated 2016. And internal research summaries they say were shared with me during the consulting arrangement. Off from the subsidiary. Holloway Technical." Yes, Holloway Technical dissolved in 2018, Malcolm said. Their asset records were transferred to the Ontario Business Registry. Those transfers are public. Claudette stared at him. If the licensing agreement is dated 2016, he said carefully, and references a proprietary system Holloway claims to have owned, you'd want to know when that system was actually registered, whether it existed in 2016. He picked up his toolbox, set it against the wall. Because if it didn't exist until later, then the agreement is either backdated or fabricated. And if it's fabricated, there'll be something wrong with the metadata. There always is. She was very still. How do you know that? I read, he said again. And then, because that wasn't enough, because she was looking at him like she was trying to decide if she was dreaming, and I had a case 3 years ago. Custody. My ex's family had a lawyer who filed documents they said I'd signed. I hadn't. I had to figure out how to prove it myself because I couldn't afford anyone to help me. He looked at the folded picture in his pocket. You learn. What happened next was not, strictly speaking, how proceedings were supposed to go. Judge Kwan had extended the recess to 11 o'clock, which gave Claudette 45 minutes to locate and print the Ontario Business Registry transfer records for Holloway Technical's assets. The courthouse had a public access terminal in the registry office on the second floor. Malcolm knew where it was. He also knew where the court's certified document request desk was, and how long rush requests took, and which clerk was most likely to expedite one if you explained the situation calmly and didn't make it weird. By 10:50, Claudette had a thin folder of documents and a man in a gray work uniform standing just outside the courtroom doors. I can't come in with you, Malcolm said. I'm not admitted. I'm not anything, I know. But if there's a recess or if they introduce those documents, I'll come find you, she said. She went in. He went back to the window and finished the weather stripping. Dennis Haverford opened for Corland with the confident ease of a man who has given the same argument in 7 different rooms and won 6 of them. He laid out the chain of derivation. Claudette's consulting work for Holloway Technical in 2015 and 2016. The research she had access to, the unmistakable structural similarities between Holloway's internal framework and Lumara's forecasting model. He introduced the licensing agreement. Judge Kwan examined it. Claudette, sitting alone at the defendant's table, said, Your Honor, may I ask when that document was created? Haverford blinked. The document is dated. I'm asking about creation metadata, Claudette said. The digital file. When was it generated? There was a brief, strange silence. I'm not sure that's... Mr. Haverford, Judge Kwan said, can your team provide the original digital file for this document? The second chair whispered something to Haverford. Haverford's expression did not change exactly, but something behind it shifted. We'd need time to. That's a simple question, Judge Kwan said. She had the tone of someone who had decided something. We'll recess until 2 o'clock. I'd like the native file with full metadata by 1:30. Claudette found Malcolm in the corridor. She handed him the Holloway Technical transfer records without speaking. He flipped to page 4 and pointed to a line. Their proprietary analytics framework, he said, registered as a transferred asset in March 2019. Not 2016. 2019. He looked up. Licensing agreement that supposedly predates Lumara was signed 3 years before Holloway even registered the thing it was licensing. She read it herself. Read it again. That's not a clerical error, she said. It's not. She looked at him, really looked at him. Why are you doing this? He thought about how to answer that. He thought about the custody hearing 3 years ago, the folder of documents he'd brought that a lawyer had told him were inadmissible because he'd compiled them himself. The judge who had nevertheless looked at them and asked the other side to respond, the way the truth had mattered, despite everything trying to make it not matter. He thought about Rosie drawing a lion that morning, and him asking her why a lion, and her saying very seriously, because lions are scared sometimes too, but they still go. Because it's the right thing, he said, which was true. And also, and I've got time until my next job at 2. She almost laughed. It was a real laugh this time. The afternoon session changed. Haverford produced the native file. The metadata showed a creation date of January 2022. licensing agreement, which bore a date of 2016, had been created 6 years after the date printed on its face. Judge Kwan looked at it for a long time. Then she looked at Haverford. Then she called a second recess, this one longer. And when she came back, her expression was the particular expression of someone who has decided to take something seriously that they had expected to dispatch quickly. Claudette, working from the Holloway transfer records and 3 other documents she'd pulled from the public registry terminal, laid out the chain herself. Her voice was steady. She was not a lawyer. She said so directly at the start. She said she was presenting factual record evidence that she believed the court could verify independently. She said, the system Corlin claimed she had stolen did not exist in any registered form until 3 years after Lumara was founded. She said, the document introduced to prove otherwise had been created in 2022. She said she did not know who had created it. She said that was a question for investigators with more tools than she had. But she said the documentary record was clear and she asked Judge Kwan to look at it. Judge Kwan looked at it. The ruling did not come that afternoon. These things never resolve as cleanly as people want them to. But Judge Kwan did something that afternoon that mattered more in some ways than the ruling itself. She ordered the original Holloway technical files, not copies, originals, to be subpoenaed from the Ontario Business Registry. She noted, for the record, that a material discrepancies existed between the creation metadata of Corlin's primaries exhibit and the date printed on its face. She noted that this discrepancy had been identified by the defendant, who was self-represented. She noted it twice. Dennis Haverford asked for a continuance. He got one, but his expression, leaving the courtroom, was not the expression of a man who expected to win anymore. Outside in the corridor, Claudette stood for a moment just breathing. Malcolm was packing up his toolbox near the east stairwell. He had stayed, nominally, on a different task, one that had somehow taken most of the afternoon. She walked over to him. She didn't say thank you, not right away, because thank you felt like the wrong size for what had happened. She just stood there for a moment beside him. How's your daughter? She said. He looked at her sideways. He'd mentioned Rosie in passing, in the way you mention someone when they're simply part of everything you think about. Good, he said, probably wondering where I am. Tell her the lion showed up today. He was quiet for a moment. Then he said, yeah, I will. The case concluded 4 months later. The subpoenaed originals confirmed what the metadata had suggested. The intellectual property claim was dismissed. A separate investigation was opened into the fabricated document, not by Claudette, not by Malcolm, but by the Law Society and the Ontario Securities Commission, who had been watching Corlin's practices for reasons unrelated to this case and had found what they needed. Victor Ashburn resigned from Corlin's board in January. Lumara Energy Solutions won a municipal contract in March, the largest in the company's history. Claudette did not throw a party. She went back to work, but she did one other thing. In February, she called a meeting with her board and proposed allocating a portion of Lumara's annual revenue to fund a legal access program for small business owners in Ontario who couldn't afford representation in commercial disputes. The proposal passed unanimously. She named the program after the idea, not the person, because she knew Malcolm would have it no other way. She called it the Clear Record Initiative. The tagline was simple: the truth needs somewhere to stand. Malcolm found out about it from a news article his cousin sent him. He read it on his phone on his lunch break, sitting in his car in the courthouse parking lot, eating a sandwich Rosie had made him that morning. Slightly too much mustard, cut diagonally because she'd decided diagonal was better. He read the article twice. Then he put his phone in his pocket and finished his sandwich. When he picked Rosie up from school that afternoon, she asked him how his day was. He thought about the right way to describe it. Good, he said. I fixed a window. She considered this. Was it broken? He said. It was letting in a draft. She nodded, satisfied with this, and climbed into the back seat and started telling him about a disagreement she'd had with a classmate over the correct pronunciation of particularly, and he listened to every word, and he drove. And the October light came through the windshield, the way it does in southern Ontario in the fall, low and golden and a little sharp, and it was All things considered, a good day.